Welcome everyone. Welcome to this month's April's webinar for the ELGA webinar series. As many of you may know, this series has a different host and a different theme each month. Before I introduce the theme for this month, however, I'd like to welcome everyone and I would like to acknowledge everyone's country, or the country that we all inhabiting today. This is a practice common in Australia, but I know that it has emerged as a practice of acknowledging land in different parts of the world. And in so doing, obviously, I'm acknowledging the legal and political implications of the concept of country. But more than that, country, in the words of Deborah Burt-Rose, is the nexus of identity and interconnectedness. It is the total sum of all the beings and phenomena with which we individually engage with at any particular point in time. Even more than that, it is the total sum of the interactions with and amongst these beings and phenomena. And beyond that, country is the total sum of the stories within which these interactions and intersections are contained. And so with that in mind, I'd like to pay my respect to the knowledge holders, the elders, the ones who were, the ones who are, and the ones who are yet to be. With that in mind, I would like to welcome you to this particular space, virtual space, obviously, and to this particular webinar. This webinar will be focused on the launch, or I should say the soft launch of the Eco Jurisprudence Monitor, an initiative that we will explain throughout the hour or so that we have together, leaving enough space after that for questions and answers. If you do have any questions, please, and they're particularly urgent, please feel free to put them in the chat, and we will address them at the end of the presentation. The presentation will be interwoven in that the three speakers today will be speaking to each other in a form of a dialogue. So it is my absolute pleasure to introduce the speakers today in the order that I can see here: Linda Sheehan, Alex Putzer, and Craig Kaufman. Now, my three colleagues and I, we all part of the Academic Hub. We're co-founders and part of the Academic Hub for the Global Alliance for the Rights of Nature. We will introduce briefly both what the Global Alliance for the Rights of Nature is and what the Academic Hub is in a moment. So without any further ado, I would like to pass it over to my dear friend and colleague, Linda Sheehan, to introduce today's webinar. Thank you.
Great, thank you, Alessandro, and thanks to all of you. I would like to start, as you did, by noting that I'm speaking from the unceded territory of the Ramaytush Ohlone, which is currently known as just south of San Francisco on the San Francisco Peninsula. I'm really looking forward to this conversation today because it's come about through a number of years of activity by folks working all over the world, and will continue to move forward in this way in a really wonderful collaborative effort. And I'm probably going to touch on some things that some of you are familiar with, but for those of you who aren't, I'd like to start back at how the Academic Hub, which actually created the monitor, came about. And it's an outshoot of the Global Alliance for the Rights of Nature, or GARN, which was formed, as many of you know, in late summer of 2010 at a meeting held in Ecuador with founding members from around the world, including the US, Africa, Australia, Asia, and Europe. The establishment of the Global Alliance arose out of some major developments in the movement around rights of nature worldwide, including adoption of rights of nature in Ecuador's constitution in 2008, and adoption in Bolivia at the World People's Conference on Climate Change and the Rights of Mother Earth of the Universal Declaration on the Rights of Mother Earth. So following those two major events and other activities for rights of nature around the world, GARN adopted a governance document with their establishment in September of 2010 to help guide this collaborative work and create structure to achieve common goals around the universal adoption and implementation of nature's rights and legal systems that respect and enforce the rights of nature. Fast forward a couple of years, in 2014, GARN sponsored its first broad international gathering on the rights of nature to exchange information about this rapidly growing movement, and held its first rights of nature tribunal in Quito. And GARN has since sponsored several more international rights of nature tribunals, often to coincide with the International Climate Change Conferences, or the COPs, as well as local tribunals, including 2 in the area that I live and work in right now. To celebrate the 10th anniversary of the inclusion of rights of nature in Ecuador's constitution, GARN again sponsored an International Rights of Nature Symposium in Ecuador in September of 2018 to exchange more information about this movement. And this large gathering was followed by a meeting of the executive committee and advisory board members who worked hard to develop and refine a system of advancing nature's rights through a decentralized, regional, and thematic set of hubs of partners working around the world, to allow people more agency to spread this word and work together. So the intent of these hubs is to deepen localized grassroots engagement and increase networking opportunities for the organizations, communities, and individuals that were working on rights of nature campaigns and cases in different parts of the world. So these hubs include regional collaborations, such as in Africa, European, Latin American hubs, and partner collaborations, such as the Indigenous Council and the legal and youth hubs. And the academic hub, of course, is yet another example. And you can see more information about these through the Global Alliance website. GARN sought to not just sort of set up these hubs, but also to give them a good start through providing some seed funding and project funds for the hubs to launch their work through a facilitator and enable them to move forward effectively. The role of each hub facilitator was to do an initial mapping and invite key people to get the hub started. Craig, who you'll hear from soon, released a mapping transnational network study in early 2020, which helped identify some of this work being done and in ways that perhaps hadn't been known, and allow us to be able to identify more potential hub participants and be more inclusive. Alessandro joined the executive committee of GARN shortly after this planning activity and took up the role of facilitating the academic hub as well. As these hubs started to come together, GARN adopted new policies to incorporate the hub facilitators into the Global Alliance's executive leadership. So now the structure of the executive committee of GARN has been expanded to include all regional and other hub facilitators. And Alessandro plays a double role as both the Oceania and academic hub representative on the XCOM, so very busy. The academic hub itself was founded to harness what was an rapidly expanding and multidisciplinary scholarship that's developed over the years, especially over the last decade, around legal structures to respect and enforce the rights of nature. The hub's broader goal is to extend to all disciplines, scholars, and research projects connected to the emergence of rights of nature and ecological jurisprudence generally, and to create space for critical inquiry and to facilitate and foster new research. There's a hub planning document for the academic hub, and it articulates the main goal of this hub is to leverage educational pathways to increase knowledge sharing and raise global awareness, with the hope that this will in turn open the gateway for the general public to welcome rights of nature and earth jurisprudence into local, national, and international governance. And it's important to note that right from the start, Indigenous cosmology and traditional ecological knowledge both inform and underpin the academic hub's goals and activities. So an essential core foundational component of all the work the academic hub does. So the first and major project of the hub was to establish a repository of rights of nature and other ecological jurisprudence initiatives across the globe. The plan was that this repository of initiatives would also include secondary literature, such as books, peer-reviewed journal articles, et cetera, as well as direct links to the literature, both primary and secondary, whenever possible. The academic hub got GARN seed funding and other funding to start work in 2020. And the initial hub members working on the Eco Jurisprudence Monitor, or what would be the Eco Jurisprudence Monitor, were sought out to really represent diverse global membership with a wide range of age and experience, and including Indigenous leadership, scholarship, and wisdom, to really try to be as inclusive as possible, not just in terms of the substance of what came out of this work, but the methodology, the process by which it was done was also quite important to the group. So before we dive into the monitor itself, just a couple quick notes on the work that had been done to try to do some of this work. that the monitor represents, and give some respect to those particular efforts. First, the Global Alliance itself has developed a timeline and a world map of nature's rights initiatives, which are still on the Global Alliance website. The rapid expansion of this movement, which is wonderful, has also required increasingly frequent attention to updates and categorization of these tools. And it was determined this work was growing so quickly that it merited its own attention and own funding as a separate standalone project. GARN itself has focused more recently on its work with the rights of nature tribunals, including the development and regular updates of a map that tracks the details of tribunals, which is you can find right now on the tribunal website. And GARN will also be tracking the organizations involved with the tribunals worldwide, and organizations working worldwide more generally on the rights of nature. And all of this work that GARN is doing will complement the Eco Jurisprudence database, which focuses solely on legal initiatives. The repository of legal initiatives that you're going to be hearing more about also builds on the UN Harmony with Nature program, which arose out of 2 UN resolutions in 2009. The first of these resolutions recognized the 22nd of April as International Mother Earth Day. The member states acknowledge that the Earth and its ecosystems are our common home and express the conviction that it's necessary to promote harmony with nature to achieve a just balance among the needs of present and future generations. The second 2009 resolution by the UN specifically addressed the Harmony with Nature program and began a series of General Assembly dialogues that addressed Earth-centered governance. The next UN dialogue actually is this Friday, and you can sign up and view it online. So finally, the Harmony with Nature website also lists experts and their work in Earth-centered disciplines, from law to science, economics, food systems, ethics, education, spirituality, and other disciplines. It also itself offers a compendium of nature's rights, laws, and policies, which you can see on their website right now. While it's relatively comprehensive, again, regular updating poses an ongoing challenge in light of the rapid expansion of the movement. More broadly, the academic hub's work sought to examine whether the scope of nature's rights compendium should be broadened to include other Earth-centered law initiatives grounded in a wide range of local contexts, particularly indigenous local contexts, but not limited to that. That's the work that I'll be diving into more deeply after a bit of background from Craig and Alex, and I'd like to turn the mic over for further information to Craig.
Hi, thank you, everybody. So I also will acknowledge that I'm speaking from the University of Oregon, which is the traditional land of the Kalapuya peoples. And as Linda noted, the story of the creation of the Eco Jurisprudence Monitor is really a coming together of several different stories that came and merged in 2020. And so I wanted to say a little bit about how I came to be involved and sort of the extent to which the project grew out of my experience. So as a professor at the University of Oregon, I had been working for many years with my colleague, Pam Martin, to try, as a researcher, to try to, track what was going on in the field of rights of nature. And so became involved with Linda and the GARN project that Linda described, as well as the UN Harmony with Nature initiative, and worked with Maria Mercedes Sanchez. We were essentially communicating, sharing, information, because it became clear that it was too large of a project really for any one person to tackle on their own, right? And also it was difficult to, it became clear that it was not sufficient to rely just on self-reporting, kind of like the UN Harmony with Nature program was set up, that we really needed a group of people who was dedicated to actively researching these and compiling them in real time. So in 2018, I was approached actually at the Symposium of the Global Alliance for the Rights of Nature in Quito by Tom Cruise of the Rockefeller Brothers Fund, which had given seed money to many of the organizations that were working to advance rights of nature. And he told me that he was looking for data on the global rights of nature movement that he could use to convince his board to invest more money in the movement, because basically he had concluded that the movement at that point had matured to a point where he thought there was some big potential there where they could get bigger payoff by greater investment. But to convince his board of that, he needed actual data to prove to them that there was something there worth investing in. And so he, I guess, had heard that I, as an academic, was trying to gather information on this and asked me if I had it. And I basically said, look, I am trying to compile this, but it's taken a long time because it's just me, and sharing information with whoever I can find would go a lot faster if you gave me money to hire some research assistants. And so, long story short, he did. And so in 2019, I had a grant from the Rockefeller Brothers Fund, essentially to fund two kind of projects that were integrated. One of the main ones was to try to create what, as best as we could, verify the definitive list of rights of nature initiatives. And then at the same time, he was interested in trying to understand who's working on this, how are they related, that sort of thing. And so I developed a survey, which was designed to elicit information about who was working on rights of nature and related issues, and then who was partnering with who and what kinds of partnering were they doing. And so I conducted that survey in 2019, which was used to do a network analysis, which Linda referenced. But for the purposes of the Eco Jurisprudence Monitor, I guess the relevance of that project was that it gave us what at the time I think was the most complete list of rights of nature initiatives as the main product. The problem, of course, is that the grant was a one-year grant, and the money ended, and I couldn't hire the research assistants anymore. And yet rights of nature continued to flourish, and the number of initiatives continued to expand rapidly. And so the data set quickly became out of date. But fortunately, right about that time, I received an email from Alex Butzer, who explained that he was a graduate student who was studying rights of nature initiatives for his graduate research, and asked if I would share my data set with him, which I did primarily because I was hoping that he would take it and update it and expand it, which is exactly what he did. So I'll turn it over to Alex to explain what he did.
Thank you very much, Craig. That's exactly what I did. I got your context from Maria Mercedes Sanchez, so it's all going through contacts there. And I want to share just a few anecdotes on the difficulties of expanding this list. So Craig and Pam shared their database with me, and I'm going to share my screen a little bit because that makes it more visual. So what did I do? Basically three things. I was looking at Craig's database, going through all existing other databases. So it was already mentioned that Garn had one mapping effort, Derechos de la Naturaleza for Ecuador. And so going through all these links and trying to see what's going on. This is the rights of the Harmony with Nature program by the United Nations. And what the methodology basically was is to see if there is a legal document underlying. So if you're going, for instance, on here, click official document, I hope you can see the new link, then perfect. If I find one of those documents, that's perfect. And this is an initiative. Now, the problem with some of those lists, and if it's only a few people that update it, for instance, here for Brazil 2015, if I click on that, then I see we're having trouble finding that site. Websites go offline, websites are quickly going out of date. So a lot of times I tried to download the document, sometimes I forgot about it, and then we also lost some initiatives. Once those existing databases were gone through, this fact-checking went a step further. Here is an example for Civita Castellana in Italy, where the only proof that this initiative exists is this picture, and I have yet to find that real document there. So sometimes it's happening there. Then another example, some of you might be familiar with Curridabat in Costa Rica. That's a suburb of San Jose, and there was this rather, I would say, popular article that claimed that Curridabat gave citizenship to bees, plants, and trees. which is a great initiative. Unfortunately, the journalist of this article did not link to any official document. So I contacted here Patrick Greenfield, and basically he told me, well, if you contact the municipality themselves, I'm sure they'd be happy to help. And that's what I did then. And then Irene Garcia Brines responded and sent to both Craig and me a couple of documents. Reading through them, there wasn't really the document we were looking for. To make a short story shorter, they didn't do it in a sense. There was the article written about the initiative, but the initiative itself wasn't done. And so here is the WhatsApp group of abejas, so bees in Curridabat, where currently in connection with the Earth Law Center, we're trying to set up that initiative. So it's going down a lot of rabbit holes. But it doesn't need to be that negative. A positive one is, and that's the last one, and then I leave you for the community of Acri in southern Italy, that were also supposedly, they recognize the rights of nature. And so I went on their website and was looking, okay, numeri utili, so useful numbers, and basically went through all the numbers that are here, and none of them responded. I don't know if my phone was the problem or anything else, but then there was this ad of the Museum of Modern Art of Acri, and I was like, okay, might as well just try there. And that website is actually offline now, so can't do that anymore. But then Massimo, I think was his name, responded, and it's a town of 20,000 people, but by coincidence, he knew the person that initiated that initiative, and within 2 hours I had the document. So it's maybe a mix of this, of patience, insistence, and luck that then led to an expansion of this database. So that as a bit of anecdotes, I give the word back to Craig. Thank you.
Yeah, thanks, Alex. And that, I think, illustrates a really important lesson that I learned through my experience in 2019 trying to do this, which is that, one, there is really a lot of, there are a lot of rumors it's easy for rumors about new rights of nature initiatives and other initiatives to get started, and they somehow get perpetuated. And some of them are just incorrect, right? And there are a number of the Curridabat case is just one of several that I found where there were rumors that rights of nature had been recognized in some legal document, but then when we chased it down, we found out that indeed they didn't actually recognize rights of nature. And so that also shows the importance of not relying just on self-reporting and the need for researchers both to actively look for cases, but then to verify them and try to collect the original documents and house them in a place where the links will be stable over time. And so these are all aspects of the Monitor project that are meant to try to improve on our past efforts, essentially. And so to continue the story, as this was going on, in mid-2020, then Tom Cruise from the Rockefeller Brothers Fund contacted me again to essentially to follow up on the previous project and to discuss creating a more sustainable system for tracking rights of nature initiatives. And the way he thought of it, he called it the equivalent of a Sabin Center for Rights of Nature, right? To match the Sabin Center's climate litigation project. He was envisioning, he was just trying to see if I would be interested in trying to work in creating some sort of center that would be like the Sabin Center, but that would focus on tracking rights of nature initiatives and creating some sort of sustainable human infrastructure for researching and verifying these initiatives. And so we brainstormed what this might look like together, and he invited me to write a grant proposal to submit to Rockefeller, which I did. And then again, as I said, from the previous experience with trying to track rights of nature, and also learning from Alex's experience, I knew this would require a more decentralized network system in which many people around the world would actively be looking for initiatives, which could then be compiled and verified and eventually made publicly available by sort of a core team of researchers. So serendipitously, it was during this same period that I was contacted by Nati Green of the Global Alliance for the Rights of Nature, who asked if I would be interested in helping form the academic hub of GARN, which Linda described. And as she described, like the idea was to essentially organize a global network of scholars doing research on rights of nature and other aspects of ecological jurisprudence to facilitate collaboration on projects. So, and this happened like literally within days after my meetings with the Rockefeller Brothers Fund. And so it was immediately obvious to me how this kind of academic hub could provide the kind of human infrastructure for a rights of nature tracking system. And the idea, in my mind, that's how the idea for the Eco Jurisprudence Monitor was born, essentially. And as Linda noted, a diverse group of about 10 or 12 scholars representing various regions and cultural backgrounds formed the academic hub in sort of late 2020 and early 2021, which was when I was writing the grant proposal. And so in April 2021 is when the Rockefeller Brothers Fund grant came through. So we have a 2-year grant to create a basic platform and an infrastructure that could then be built out over time. And so we're now 1 year into this initial 2-year project. So I just want to kind of build on something that Linda said at the beginning, but I think it's important to emphasize. You may be wondering, why do we call it the Eco Jurisprudence Monitor and not the Rights of Nature Monitor? And the answer is, as Linda said, is that we've all learned, I think, from our experience working with the UN Harmony with Nature program and talking with indigenous peoples and others in various regions, that rights of nature is just one of many different legal and cultural expressions of what you might think of as ecological jurisprudence. And this idea was emphasized in early discussions among members of the academic hub. And so we agreed that it was important to try to facilitate understanding and collaboration among advocates of these varied expressions in order to advance more eco-centric legal and governance systems, which we obviously think is necessary to address the environmental crises we face. So we decided early on that the monitor would track not just rights of nature initiatives, but all kinds of ecological jurisprudence to try to build connections and understanding among different movements and communities that represent different cultures and that arguably have similar goals overall, but maybe working at best in parallel or at worst even see each other as competitors. So Linda's going to talk in a bit more detail about how we define eco-jurisprudence and sort of the categories we created, but just sort of quickly, basically it refers to the current global trend within legal theory and practice to reject the anthropocentric assumptions that underpin today's dominant legal traditions. So some of these initiatives use rights-based framings, such as animal rights or rights of nature, while others instead emphasize human responsibilities and accountability. Examples of the latter include ecocide laws or laws promoting ecological civilization, earth system governance, as well as various place-based approaches that draw on indigenous and other forms of traditional ecological knowledge. And there's, of course, many other examples. So again, it was important for us to design the monitor in a way that's inclusive of different perspectives and also seen as useful by various audiences. So to that end, we began by conducting a survey before we even began, before we started designing how the monitor would be structured. We conducted a survey of various activists, lawyers, and researchers working in different aspects of ecological jurisprudence to get their feedback on how they conceptualize eco-jurisprudence and what kind of information and resources would be most useful to them. And from the survey, we got a lot of good information about how different people conceptualize types of ecological jurisprudence. And also 2 broad goals emerged. So one is to be able to identify all initiatives, like Linda said, create a repository of initiatives that we could track and code according to different categories so that we could analyze general patterns and trends. So that was one goal that people identified. And the second goal, though, was to be able to understand the context of individual initiatives, recognizing that the text of laws does not tell the whole story in terms of what's happening on the ground. So based on this, we created the Eco Jurisprudence Monitor with a dual underlying structure. Right? So one is a data set that identifies initiatives and codes the related legal documents according to various categories, which Linda will describe in a bit. And the second part of the structure then is a distributed network of web pages that provide information and various kind of resources on the context of individual initiatives. So I just want to share my screen quickly to give you a sense of sort of the structure of the monitor. So the monitor contains 5 programs that use these 2 structures to provide many different kinds of resources and information. The heart of the monitor is the Eco Jurisprudence Tracker here. And this is a dashboard that tracks eco jurisprudence initiatives worldwide, that provides summary information about them and allows users to interact with the information using a map interface, but also search tools and filters and various data visualization tools. And then the legal toolkit, for now, initially, it's the place where the original legal documents are stored for each initiative. So we'll can be sure that we have stable links and that users can search using various filters in a search bar. Over time, we also plan to provide multimedia resources like short videos in which experts talk about the pros and cons of different legal provisions and the context in which various kinds of legal provisions might be most appropriate. This was something that many activists said they would like in the survey. And I just note that the Eco Jurisprudence Tracker and the legal toolkit are the first components being built out, and they're very close to being completed. We're hopeful that they may be available to the public sometime this summer. And then a third program that we're just beginning to work on is called On the Ground Stories and Strategies. And again, this came out of the expressed desire of potential users of the site to have more context about, the politics, if you want to think of it that way, surrounding the legal documents. So the goal of this program is to provide rich description and context about individual initiatives and allow activists to tell their stories in their own words, why the origin story of the initiative, the obstacles they face, and why they chose the strategies they chose, in the hopes that this can provide an important learning tool for other people. And so this again will include various multimedia resources, including videos, images, and written essays. In the future, we also plan to add a searchable database of existing publications on ecological jurisprudence, which we will call the Eco Jurisprudence Library. And this will be developed in the next stage of the project after we secure additional funding. We'll probably start working on that in 2023. And finally, the monitor will have an outreach program. And I'm very excited to say that Laura Burgers, a professor of law at the University of Amsterdam, has agreed to manage a blog that will provide a platform to discuss and debate various issues related to ecological jurisprudence. And so we'll also provide news about new initiatives, events, and so forth in that part of the monitor. So with that, I think I will hand it, let me see if I can stop sharing my screen and then hand it back to Linda.
Great, thanks, Craig. Your remarks are just, there's so much to dive into, and so many things that that you said that are so important that we could have a webinar on each of them. But it really starts to illustrate. I'll dive in a bit more. It really starts to illustrate the challenges with digging in and trying to do this work in a really rigorous way, but it's also very thoughtful and inclusive. And that is not limited to one way of learning and understanding, and also realizing where we've made some errors and want to try to correct that, where there've been some misunderstandings of local initiative, particularly the point that Craig just raised about embedding local context while still being relevant internationally is so incredibly important, because legal initiatives arise in very different local contexts and can mean different things to the people who initiated them, and we need to understand and respect that work. And just overall, I think one thing Craig said that it bears repeating is that what we're trying to do with the data set is to raise and provide information about challenges to the anthropocentrism of law, the way that we center law around the human, and decentering the human in law is something that can be done in a number of ways. Rights-based approaches are one way, but the overarching goal is to recognize more eco-centered law and practices, and that can include rights, responsibilities, and other ways to envision how we guide our own behavior and how we can learn to go forward in a way that is more respectful to each other and the earth. So, you know, just diving into what Craig had talked about, you know, digging in as in our initial conversations as a group, we talked about all these different initiatives and trying to give respect to the pluralism of approaches that we could address. And that's how we came up with the idea of making this an Eco Jurisprudence Monitor, so we can include both rights and responsibility-based approaches. And this suite of legal initiatives, and even the word initiative took a long time to figure out, but it includes legal provisions that contain elements of ecological jurisprudence as defined through two principles. One is legal initiatives that transcend an anthropocentric view, that recognize the value of all beings and interconnectedness among them, and also legal initiatives that recognize ecological primacy, that respect planetary boundaries and the limits of ecosystems' carrying capacity. Many ecological jurisprudence initiatives also seek ecological justice by ensuring equitable access to the Earth's capacity for present and future generations, and also avoid inequitable allocation of environmental harms, which we're certainly doing right now. So examples, which we'll talk about, include the rights of nature, animal rights, the criminal nature of ecocide, rights of future generations, of course, indigenous traditional ecological knowledge, and also initiatives that emphasize the need and responsibility to maintain ecological system functioning. The thing that brings all of these together in this data set is that, just to emphasize, it includes only formal legal provisions, that is, initiatives with some level of formal authority. The two exceptions are citizen tribunals, like the International Rights of Nature Tribunals, and civil society soft law. And as I'll touch on, we included these because we decided they play a very important role in stimulating the development of more traditional laws, such as soft law and other laws, and help provide more illustrations of normative change that can be achieved at both the domestic and international level. So those are the only two exceptions. Otherwise, this is formal legal provisions of some kind. So as Craig touched on, we, you know, there's a lot to wrap our heads around with this, but one of our chief goals was to make this useful, something that people could use and that could evolve over time. But to be useful, we needed the rigor of a code book, specifically data set categories that could be established with terminology and definitions that could help guide how we put these initiatives into different categories, and we'd be very transparent and inclusive so that other people could replicate what we had done. So I mentioned there's a lot of challenges as we went along, and part of it was because we were a diverse group from different countries and different legal traditions and also different disciplines. And one example is unraveling of what we meant by case. We initially referred to the legal initiatives as cases because the social scientists in the group use that word to denote an instance of a phenomenon that's being studied. But, you know, we lawyers said, well, that's just, you know, a lawsuit. So we're very confused. So we chose initiative for that reason, but also because that term initiative captures the essence of what this is, which is really a process. It's not something static. All of this is ongoing, not just the law and the expansion of the law, but how we understand it and how we ourselves grow and expand our thinking. So we think that legal initiatives was the best terminology to be able to ground all of the work that we're doing. So what I'll do now is just run quickly through the data set categories. So when Craig gets to the very interesting work and sort of discussing the types of things and information that we can generate out of this, I just want to be able to ground that the methodology for developing this was carefully thought out, but it can always be even more carefully thought out. So questions and comments are always welcome. So the first few data set categories are very straightforward. You know, the identification number, you know, you add a number for an initiative as it comes up, the name of the legal initiative as it's reflected on the original legal document, again, making sure we're being as accurate as possible, referencing back to the original documents. Latitude and longitude of the initiative, where it was initiated, the country, and putting down international, if it's an international initiative like a UN or transnational with multiple countries. The location, local, state, if that's available, the region, Africa, Asia, Europe, etc. Again, trying to categorize these in ways that can be useful and identifying them going forward and to be able to compile and share information. So the next big category of information within this data set is initiative type. So developing the terminology and the definitions to categorize the types of legal initiatives that we'd be addressing took up quite a bit of time. And it makes that sound like that was uncomfortable, but it was actually quite fun to be able to debate this with such talented academics coming from different traditions. I myself learned a tremendous amount. I'm very grateful for the process. So we came up with a suite of different types of documents, and when we finally get a sort of the critical mass of documents in there, we'll go through and comb through and make sure that everything looks like it's accurately coded. But the categories that we came up with were first international document, which is treaties, declarations, resolutions, charters, agreements, typically made between nation states, but also intergovernmental organizations like the UN or the EU, and of course includes declarations and documents between indigenous nations and nation states. International documents does not include international court cases, which we decided went under cases, which we'll get to in a minute. Other examples of an issue type include constitutions, fairly straightforward, indigenous constitutions, and legislation, which is coded as indigenous law. Another category was statutes and direct legislative documents, which are coded as statutory law. And this includes sort of a traditional legislative driven statute, but also we decided to include executive orders in the US, executive body orders. And an example in civil law would be decrees. It does not include administrative regulations, though. The next category, which I think we spent the most time on, was local/delegated legislative initiatives, which we coded as local law. And this includes what you might think of as in the US would be an ordinance, or Canadian bylaws would be the equivalent, local or regional legislative body of law. Basically subordinate legislation made by a body other than a legislature as delegated under a primary piece of legislation. This also includes administrative regulations as understood, for example, in the United States, although the term regulation can sometimes be used in civil law countries to refer to guidelines without the force of law. This particular category was regulations with the force of law. Without the force of law was the next category, which was policies. These are typically non-binding government guidance documents that provide information on how to implement legal mandates. And this is where we capture this civil law society of understanding of the word regulations that don't have the force of law, protocols, guidelines, that type of thing. An additional category of legal initiatives would be government, official statements, declarations, resolutions, and this includes formal statements of intent by a government, which includes indigenous declarations. Cases was cases, lawsuits, and that includes international court cases as well. Citizen tribunals and soft law are the last two categories. And as I mentioned earlier, those are the only two exceptions to our understanding of what the data set is, which is just formal government associated law. So citizen tribunals are civil society tribunals that are operating independently of government authorities, like the GARN's International Rights of Nature tribunals. And then soft law is an expanded definition of what is traditionally understood as soft law, which expresses ecological jurisprudence that it's accepted and endorsed by multiple civil society organizations and illustrates what soft law could look like. And it helps us understand how to transition to more ecological law. And the classic example of this type of soft law would be the Universal Declaration on the Rights of Mother Earth. So those are the suite of legal initiatives and how those are coded in the data set. The next set of categories that the code book contains are the status of the particular legal initiative that's being addressed. And that would be the most recent status, drafted, submitted, approved, stayed, on appeal if it's a case, or rejected, or overturned or repealed. So whatever the most recent information is, was be coded in. The next sort of larger suite of categories falls under this idea of theoretical framing. What is the language that was used in the original legal document to describe the ecological approach that's inherent in the initiative? And what does that mean? An example would be, the theoretical framing of the legal initiative would be rights of nature, or ecocide, or legal personhood, earth democracy, et cetera. Wanted to capture the essence here of how the ecological approach is framed. So this category has the description, and then the next several categories allow us to be able to compile and map the data by having certain examples be coded either 1 or 0, so we could compile those more readily. So for example, if the legal initiative is a rights of nature initiative, it would be coded 1. Animal rights, you would code that 1 if it's animal rights, and also that would also be a 1 in rights of nature because it's a rights-based initiative. Other what we call dummy variables in this category, in these categories, would be local ecological knowledge and indigenous models. And just to quickly explain, if the legal initiative is led or co-developed by an indigenous group as they identify themselves, that would be an indigenous model. But the group decided that non-indigenous or campesino groups can also have important information developed over many years that they have developed from their sense of place. And if they self-identify as connected and having a relationship with a sense of place and information and knowledge that arose from that, we would respect and recognize that local ecological knowledge, and that would be coded as such. And then there's a catch-all category of eco-governance systems, which is eco-centric law that's not rights-based and that does not adopt an indigenous model, but emphasizes the need and responsibility to maintain the function of ecological systems. So an example would be Earth Charter, ecocide laws, et cetera, would be captured under that particular coding and be 1 if it was defined as an eco-governance system, 0 if not. Additional information after this was the year submitted, the year the initiative was submitted, the year that it was adopted or upheld, or when the year it was rejected or overturned, again, blank if that doesn't apply. The next category would be, the suite of categories would be the initiating actor who initiated the legal initiative. So first would name, if we have that name available, and then to categorize that with a 1 or a 0, depending on whether it's indigenous, an NGO, civil society, courts, et cetera. And a court could be an initiator. For example, the Rio Atrato case in Colombia, where rights of nature was not brought up by the plaintiffs or defendants, but by the court itself. Following that, we tried to cover the other information we tried to cover in the data set was the ecological actor. So the ecological entity that's the subject of the initiative, a particular forest or mountain, for example. If it's nature generally, we try to use the words in the initiative that they use. So Pachamama for Ecuador, and some US ordinances say natural communities and ecosystems. So we use those particular words. And then we dove down and tried to divide up the type of ecological actor. So nature generally, or animal, atmosphere, desert, forest. We dug a lot into scientific assessments of different names of ecological systems in order to develop this category. And then identifying whether or not it's a specific subset of nature was the following category there. And then in addition to links to the original text, comments, and more information, which you would traditionally have in the data set, the last 2 categories are around caretaking and this idea of who speaks for nature. And typically we think about a guardianship model and somebody who articulates and stands up for nature, but we went and discussed this quite a bit in consideration of indigenous perspectives as well. We decided to use the term caretaking and tracked who can speak for nature and whether caretaking is actually embedded in the initiative and who is the caretaker. Is it government, indigenous representatives and non-governmental bodies, et cetera. So with that very quick overview of the different categories, I'd like to turn it back to Craig to dig into some of the data that we're starting to see and the way that this is starting to be developed into a useful tool. Thanks.
Thanks, Linda. So actually, before I kind of show the data, I think I was, my plan was to just say a few words about our data collection methodology, and then Alex was going to talk about some of the design work. Since our time is kind of short, I don't think I need to say a ton about data collection and protocols, other than our, our goal with this ultimately is to create an international network of researchers and citizen researchers, if you want to think of it like that, really lawyers, activists who are willing to look for and report initiatives in their area and provide updates and corrections. And so I saw Oliver Hurst's comment or question in the chat box where he asked, if GARN, or in this case, it's really the Eco Jurisprudence Monitor team, is open to recruiting volunteers to help support the maintenance and editing and research and data analysis for the monitor. Not only are we open, we are hoping to create that very system. That is sort of ultimately the model that we're seeking to develop, and so that of course involves relationship building, right? And so that started initially with the survey that we did at the beginning. We're hoping to sort of follow up and maintain relationships, but it's also then will be nurtured by continual relationship building with other various networks, and expansion of the academic hub and so forth. So I'd be happy to talk with you more about that, Oliver, and we would love your help. But we at the same time also need some permanent staff, research assistants who actively are researching and collecting information and updating the monitor. And so this involves active grant writing, which we're involved in. And basically, to try to identify initiatives, we do many of the same things that Alex identified, right? So we actively monitor various newsletters. So one of the benefits of my mapping endeavor is we now have a very large list of various organizations that have newsletters that are doing kind of various work. And so we monitor those to see who's reporting what. And we look at publications, and from the initiatives we've identified already, we now have a growing list of kind of keyword terms that give us a sense of how different communities are phrasing or framing ecological law, that then helps us to do kind of keyword searches online and elsewhere. But of course, this biases the results towards certain kind of initiatives, right? It's much easier to search online for sacred natural sites or ecocide or rights of nature than it is for various indigenous movements or models, right? And so we're particularly trying to develop relationships with networks of people, indigenous networks, as well as networks in regions like Africa and Asia, where we've had it's been harder for us to identify initiatives. I guess the last thing I want to say before I turn it over to Alex is just to acknowledge that we do follow the Global Indigenous Data Alliance CARE principles for Indigenous data governance. And one of the ways that impacts our work is, while we're trying to create a repository of the legal documents related to the initiatives, if a legal document is not already publicly available, we do not share it on the monitor without the permission of the people who instigated the initiative. And when possible, we'll still report the initiative based on publicly available information so that the initiative can be acknowledged. And then we'll actively try to seek permission to make the legal document publicly available, or provide maybe some other summary information about it. The ethics protocol is going to be even more important, of course, with our stories and strategies program. Again, our goal is for the people behind the initiative to tell their story in their own words. So this program will be built out gradually as we build relationships with various groups to do this. At the same time, we don't want to place an additional burden on activists with additional work, because we know activists are busy. So when organizations have already produced information about their initiatives, we can just link to that directly. We don't have to make them reproduce their work. So in the short term, the program's going to create a centralized hub for finding and accessing multimedia information already produced by activists that will be linked to the initiatives in the tracker and the searchable database using various filters. And then we plan to supplement this with video interviews and analyses over time. So with that, I'll hand it over to Alex, who can talk about some of our design considerations on the monitor itself, the webpage.
Thank you very much. You've been talking a lot about design already, about study design. I'm going more for the visual design. Things would also need to look good, not just because I like design myself, but also for hopefully a lot of people, this website will be their entrance to the world of ecological jurisprudence, to the world of the rights of nature. And so it's very important to have a welcoming appeal, an atmosphere that invites people to collaborate. So I want to share a few thoughts about what we came up with to create this feeling. We is a lot of people, mainly 5. It was definitely a team effort. That's Morgan Schwartz to the left here. That's the web developer. Jean Orlevik, I think that's the pronunciation, created the logo. Then, of course, Craig Kaufman as the principal investigator, Tom Manson as a web designer, myself, the Garn Academic Hub that created kind of as a short, small demos to try out different designs, and of course, then many more people that can be named. And the task was to create this interactive online platform. Now, before we could do that, what did we need to visualize? So we have the content, and Linda went into great detail on the various structures of the content. How can you visualize that? And there were those 4 main interlinked elements: the website itself, the various charts, a map as one specific chart, as well as a recognizable logo. And so we had to do some preliminary reflections of what we want, who's the audience, are there other websites that are already doing that? What specific design requirements do we need? How can we translate the academic idea into something appealing? Who can host and maintain? And Craig can definitely say more about those last things. But what I tried to do at the very beginning, okay, how can you set a strong foundation, clarify a vision of the idea? And that can be done through a mood board. And so I collected these pictures of what is the mood that people should get once they first go on this website. I chose these pictures because there is no green, so there's not the cliche green imagery of environmental protection sites. There are clear lines and shades that should stand for reliability, academic integrity, dynamic waves like the harmonious relationship. There are different levels, such as the national and international level, and just in general, an abstract theme, because the ecological jurisprudence is this legal, philosophical, ethical kind of idea. Jean took this mood board and then created a variety of logo proposals. And if you have looked at the top right corner, you could see which one we eventually settled for. The same went for the font, a lot of different fonts. We went for this classic solid one. And then we came up with this logo that you will hopefully see more and more all over the place. Now, Tom, the web developer, took a few of these mood board images and created different website tonalities. So what is the basic idea, the basic imagery of a website? We combined them into this. This is the Figma design of all the web pages. Figma is basically the website design tool of use. And after that, after we set the general idea of the website, we went more into information accessibility. And here you see different websites and how they were presenting themselves. Several different databases or lists. And they are accessible. Well, not all of them. So, for instance, CellDev kept a list also not public for a variety of reasons. But it would take a lot of time to go through all this information. We already talked a lot about it. And so we were going for intuitive visualizations. These were some some drafts that I did for a research paper that will come out soon. Instead of making all these different ideas, we settled for one main chart to rule them all. And please notice that this is not real data. This is just the design itself.
I think you should shut the fuck up.
Should I continue?
No,
Or
that's
can
not nice,
somebody
guys.
mute?
Let's just keep it all nice in here, please.
Thank you. So one chart, one main chart in that sense. Then there's a different one which shows the cumulative initiatives, and then there's a main effort that went into the geospatial visualization, which is another word for saying the map. And I could talk hours about the difficulties of finding the right map and how to decolonize maps, and the difficulties of incorporating Western, non-Western ideas. There is no north in space, distortions, 2D, three-dimensional. Can somebody mute that person? Thank you. The main focus was then that we had was the accessibility, the interactivity, and the implementability of the web page. So all these thoughts were kind of broken down into programmatic limitations and opportunities. We were using Mapbox, which is an online tool that takes off a lot of work from our web developer, and that one only had 7 different projections. And eventually we settled for the Equal Earth projection as a combination of different perspectives on this. Once we had that, this is right now the beta version of the dashboard. So the website that is being presented once you go on it. And right now the task is to balance the different charts, the map with different other bar charts. Here we have a picture of the designer's idea. And so we're trying to balance these two visions to eventually find something. So it's still a work in progress. We need to complete the dashboard as well as the rest of the website, getting out the bugs and pieces. It's also important to create a working mobile version of the Eco Jurisprudence Monitor, because a lot of people will try to access the web page also through a phone. And in order to get it up and running correctly, we also need feedback. So also need you to make this web page, this website, this hub as workable as possible. Thank you very much. And I give my Craig, go.
And apologies, sorry, Craig. I just want to apologize. We've removed the participants who were interrupting. Sorry, Alex, for the interruptions during the presentation. It was hard to track who.
Maybe I was saying something wrong.
No, not at all. But so apologies to everybody for the disruptions. But I think we've removed everyone who was disrupting. Sorry, Craig, over to you.
That's right. So I'm aware that we're already at the 1 hour mark, and I want to make sure we have time for some questions. So I thought maybe I could just very quickly run through some of the data we've collected so far, just to give people an idea. So I'm going to share my screen and just show a couple of charts that are not generated by the monitor. These were just me taking the data for the purposes of just sort of showing the interactive charts on the monitor will be much prettier as Alex showed. But one of the things you can see we've shown is we've been able to identify 415 eco jurisprudence initiatives so far. Again, we're not saying this is all there is. We're just saying these are the ones we've been able to identify so far. Again, we're sort of only a year in, and we're actively looking and building it out, and it's a living document. But you can see, just 10 years ago, it was just about 100 of these things, and the numbers quadrupled just in the last decade. So it gives you a sense of the tremendous growth in this area. Right now, the vast majority of the initiatives we've been able to identify are rights of nature initiatives. This is, again, largely because this project grew out of several various attempts to track rights of nature initiatives. So we already had these identified, and we are building on top of this. But of course, we, as Linda said, we distinguish between personhood and animal rights. Eco-governance systems are the second largest category. And we've been working hard to identify indigenous models. We've been able to identify 65 so far, as well as a number of ones that draw on local ecological knowledge of non-indigenous communities. Just get a sense of where it's emerging. North America and Latin America are the clear hotspots. A lot of these numbers, these large numbers, are being driven by the fact that you're seeing a lot of local laws being created, whereas in some of the other places you see national laws, and so part of that's driving the large numbers. But a lot of the Oceania things are stemming from treaty settlements with the Maori, as well as various initiatives that are happening in Australia. But starting to see a lot more emerging in Europe. Asia and Africa have been the two regions where we've had the hardest time identifying initiatives, and it's unclear to me right now how much of that is just because that's not, eco jurisprudence has not really taken off as much yet, or if this is just we're having the hardest time identifying initiatives in these regions. I imagine it's probably a little bit of both. So as I said before, we're actively working on developing relationships with networks of folks in these regions to try to make sure that we're capturing what is there. And of course, we are tracking what's happening in the international realm. And there are quite a few international documents that recognize ecological jurisprudence principles. In terms of what legal tools are being used, a lot of lawsuits. Again, a lot of these lawsuits are being driven by Ecuador, where, once you have it in the Constitution, that gives you greater ability to try to then enforce that through case law. And again, lots of local law. By and large, this tells me a lot about sort of the nature of the movement, right? This is being really propelled by grassroots movements who are trying to make change locally, and sometimes through case law, right? But are beginning to see, growth of national level statutory law. You might be surprised by the big number in the constitutions, because again, you may, say, well, only Ecuador and soon Chile are the two countries in the national who have recognized ecological law in their national constitutions. But there is a lot of activity happening in Latin America where subnational governments are recognizing it in their subnational constitutions. And then you see declarations policy, and in North America, a number of indigenous tribes are recognizing, in this case, rights of nature in tribal law and so forth. And again, sort of a growing body of soft law that's meant to stimulate international law and so forth. So this is, to me, one of the more interesting charts, right? Because it really matters. It's not enough to just create the law. It's got to be upheld, essentially, right? And so we track initiatives from the time they're initially drafted to then submitted, and then whether they're approved or rejected, and then we continue to follow to see if it's appealed or overturned. But by and large, the vast majority are approved, which I think is quite interesting and may not be fully appreciated in the general characterization of ecological law, where there's a lot of assumptions that this is, fantasy fairy stuff or a utopian dream, but it is actually being approved. And again, I'll sort of end on this. By and large, most of the initiatives are just addressing all of nature, sort of in the abstract or in the general. Excuse me. But where we do see initiatives focusing on specific ecosystems, they by and large tend to be freshwater ecosystems, which I think makes sense because most people are experiencing the effects of climate change and other kinds of environmental crises primarily through their access to clean water and so forth. And then you can see animals in forest and marine ecosystems. And of course, we also track space because there is a soft law declaration of the recognition of rights for the moon, which is what that one initiative is. So I will stop there, and maybe we could open it up for questions now, unless
maybe just a couple of things. Yeah, just okay. A couple of things before we do. So just to conclude, so this presentation has given a very, I think, very comprehensive idea of the work that we are undergoing and undertaking in developing the Eco Jurisprudence Monitor. But the monitor will be fully launched in October at the ELGA conference on the 13th of October in Siena. In addition to that, the monitor, as Craig said, has a number of components, many of which are yet to be fully developed. For example, the Eco Jurisprudence Library, which we will develop next year, the stories and strategies on the ground, and so on and so forth. But the Eco Jurisprudence Monitor, albeit the main focus of the Academic Hub at the moment, is just one component of the Academic Hub. The network that we're trying to establish is a quite comprehensive network of scholars, primarily scholars, given the nature of the Academic Hub, but also of interested activists and policymakers who want to not just focus on the initiative, but also reflect upon the initiatives themselves, and therefore publish and produce scholarship of all types that may be of benefit and of use for others. And so with that in mind, Craig has already indicated his email if you actually want to be involved in the monitor itself. But if you do want to be involved in the Academic Hub as a whole, and I know many of the people who are here today are already either involved or already have been in contact over time. But for those of you, particularly those of you who are simply listening in to the recording, I'll put my email in the chat box. Please contact me at any time if you do want to be involved in the work or working of the Academic Hub, and or if you do have any particular initiative that you would like to develop as that may complement the monitor or may be completely different, in that the Academic Hub is designed to support any and all scholarly initiatives that anyone would like to undertake. So as a hub, we really want to try and build a community of scholars focused on ecological jurisprudence. So with that in mind, thank you all for participating. Once again, apologies for the interruptions. I have no idea what people get out of spending time in just farting when other people are talking. Apologies for to the speakers for that. And thank you all for participating. And I would like now to open it to the floor for any questions that you may have. Yes, thank you, Lucy. Over to you.
Hello, I'll leave my camera off just so the connection isn't too bad. I'm up in Scotland, so it's not the easiest. My question was, how do you reconcile where there is a difference between the policy that exists or the initiatives, the legislation, whatever terminology you want to use, a discrepancy between that and the way that it's implemented? So you might have an initiative that looks incredibly strong, that's kind of saying all the right things, but the implementation isn't there, or you haven't seen it come into action. How do you reflect that within the monitor, or do you? I hope that makes sense.
Yeah, Craig?
I can answer that. So that is exactly the point of the On the Ground Stories and Strategies program and the related initiative pages that provide the context. It was exactly that kind of sentiment or dilemma that was expressed through this initial survey that was brought up, that there is, it's one thing to have a legal document. It's a very, it's a totally different thing, the reality on the ground and implementation. And so that's what I meant by when I described sort of this dual structure, where the data set just tells you what's in the legal documents. And that's useful information for some things. But it's the other programs like the On the Ground Stories and Strategies and the initiative pages where summaries are given, where you get more of the context that talks about obstacles, strategies for overcoming the obstacles, and so forth.
And to just add to that, there are some instances where you have one legal initiative that is then implemented by the passage of another legal initiative, at least implemented in part. And I'm thinking of, for example, a rights of nature ordinance in Santa Monica, which was in part implemented by enactment of an additional ordinance related to protection of the groundwater aquifer in Santa Monica. And those legal initiatives would be reflected in the data set, but you raise a really good question about how to tag those. So perhaps somebody looking at that could see that they were connected. So, right now there's an opportunity in the data set to have more comments. The last column is more comments. And you can compile information, even email strings, if it's a PDF and you can upload it and create a link to additional information. That could be one way to toggle some of these different initiatives that relate to each other. But I think that's a really good question, and maybe some additional thinking might help us think of an easy way to be able to link those.
One thing that I would add is that also the same initiative that was maybe not implemented could still have raised awareness. For instance, in the Ganges and Yamuna case in India that was overturned shortly after, there was no practical implementation, but quite a few people know the rights of nature or ecological jurisprudence through this initiative. So it was somehow still successful.
Brilliant question, Lucy. Thank you. Other questions? Otherwise, there's a question from the chat box about which says, what would you identify as one, to all the panelists, what would you identify as one of the biggest challenges for the advancement of ecological jurisprudence as a result of what we have identified so far? And how does the monitor help to address that challenge?
So I can talk
Linda?
about.
Oh, sorry.
Sorry. You want to go first, Linda? Go ahead.
Just briefly, it'll just take a second. I think the number one thing for me is language, in part because different legal traditions, all of them have different, as we found out, different words, different understandings, different expressions for law, but also the language that we have not yet developed for law that decenters the human. I think that there's still a lot of language and terminology that is yet to be developed to be able to allow us to express what we're trying to do in a more meaningful way.
Yeah, so there's three come to mind that came also out of the survey that people mentioned to us. So one is just that, I think part of the hope is that we can sort of build some alliances among different movements that have been working in parallel and at best not talking to one another, and sometimes just sort of engaging in sort of competition or fights rather than trying to figure out how to work together. So I think part of it is just hoping that we can create focus on common goals to facilitate collaboration across movements that might frame ecological jurisprudence differently. Another that was mentioned by lawyers is that, I've been told by various lawyers that one of the biggest challenges they face in practice is that judges, they may sort of agree with it morally or be sympathetic to it, but they believe that implementing ecological law is just not practical, and so they may rule against it for that reason. And so a number of lawyers have told me that they appreciate the monitor's ability to provide an easy way for them to find precedent and examples in other places to help convince judges that this isn't as crazy as they may think, and that it is actually, the world won't end if we implement it, and examples of what it looks like. And again, activists, I think one of the messages that the monitor sends is that there's no one right formula for how to do this. You should tailor it to your local cultural, legal, social context and so forth. And activists, I think, understand that. Many of them do. And many of them have told me that, so it's one thing to understand that, but they're not sure how to make the decision of one versus the other. And so they've been requesting information or analysis about, like, what are the conditions under which one approach might be useful versus another, so that they have a better sense of like how to pick a strategy that might work better in their particular conditions.
Thank you. Another question from the chat box: in 10 years from now, how will we measure the success of this work?
Well, we will be involving Google Analytics. So the easiest short answer, which I don't know will be the most important metric, but we'll have some metrics of the extent to which how users are using it and the extent to which they do. But I personally would also measure it by the our timeline, by the growth of ecological initiatives.
Thank you. Olive. Oh, Alex. Yes. Sorry.
No, I could say there is. You could look at the initiatives and the number of initiatives. You could look at the effect that it had, even though that might be difficult. Has there been more freshwater ecosystems saved through this? And then it's a difficult question if it was due to this. And then with the language that Linda said, if a sort of perception changed, if you're not being laughed at when you're proposing such an idea, but if you're being taken serious, that would also be a kind of a success.
Thank you. Oliver?
Yeah, really interesting event. First of all, really enjoyed every bit of it. My question was, it kind of relates to what Craig was already talking about, but how can, it's a general question, not specifically about the monitor, but how can Earth jurisprudence reconcile with other movements surrounding social justice? So for example, climate justice and justice not only for nature, but justice for both human and non-human natures. So in other words, maybe what can Earth jurisprudence offer social justice, and what can social justice offer for Earth jurisprudence? Is there a sort of reconciliation? Because they're often obviously very interconnected and they share common goals, but how do you sort of really put that into the public light and not make it seem like they're opposites or it's one or the other?
If I may actually answer that, it's interesting. It's good that you actually raise the term Earth jurisprudence, because we've chosen to use the term ecological jurisprudence, which is a term that I introduced after discussion with Cole McCallinan in 2012, as a different concept. Earth jurisprudence is a somewhat specific and culturally defined legacy or theoretical legacy that has been, as you know, primarily articulated on the work of Thomas Berry, and so it is culturally inscribed. So contained in it, there is this dichotomy or tension between rights of nature and human rights in a way. Whereas when I introduced the term ecological jurisprudence, I conceived of it as, if you want to, the ecological or ecocentric horizon that jurisprudence is tending toward. It's something that is never reached. It's a horizon that pushes both legal theory and legal practice beyond the confines of anthropocentric, or beyond the anthropocentric confines within which they are located. And so for the purpose of the monitor, then we've articulated ecological jurisprudence as two elements: jurisprudence, something that revolves or involves a legal initiative of some sort, as Lina very aptly described before, and ecological in the sense that it tends toward an ecocentric horizon that I was just describing a few moments ago. With that in mind, I think that the dichotomy between nature and culture, if you so wish, doesn't kind of disappears, in that the two don't really only exist within a particular anthropocentric tradition. It's like Descolas' work actually points to that quite clearly. So I think while there was that, certainly there was in initial rights of nature provisions, like a very clear tension between the two, and it still is in the mind of some. I think, from my point of view at least, I think that ecological jurisprudence transcends that dichotomy. And it is my hope that dichotomy is not really continuously replicated in the movement, because I think it was Vandana Shiva who said a long time ago, probably 12 years ago, she said that the issue of social justice and environmental sustainability is not separate. It's not possible to have one without the other. It's a false distinction, as I'm sure you were sort of hinting toward. But I'll let the others speak as well if they want to add any comment.
I just want to say real quickly that sort of practically, the blog that is being set up is currently being conceived as sort of formatted around a series of tough questions that the discipline is grappling with, such as the one you posed. And then the idea is to get, a couple or a group of people to each write blog posts on that, so you can get a dialogue around specific questions that relate to sort of core difficult debates in the field. And so I think it would be great to have have a series of blog posts around the question you pose, and I would invite you to write one of the entries if you like, Oliver.
Excellent.
Yeah,
And
that sounds great.
And indeed, that's a really good point. So the idea for the blog is for all of us to workshop these questions, these ideas together in a short post form, in a way. So anyone who wants to, Laura is not here today, but anyone who will want to participate into the blog, please contact me and I'll put you in touch with Laura so that you can already start thinking about what you would like or when you would like to write for the blog. And I think we have time for one more question. Matthias?
Yes, so my question is about the difference between, let's say, ethics and jurisprudence. So I just a couple of months ago, I read this article by Rokine Kalbesa on the Shona people in Zimbabwe and the idea that they have taboos on certain areas. So it's more like a norm. Of course, it's somehow enforced or sanctions that certain sites are sacred and shouldn't be, let's say, entered without any very good reason. And my question was, would this also be something to be monitored in the Eco Jurisprudence Monitor, or would you say there is still a distinction between, let's say, ethics, norms, and then jurisprudence in terms of applying this in a more legal way?
It's a good, if I may actually start an answer on that one, because it's a really good question on effectively on legal pluralism. So how do we define the boundaries of what the law is in a comparative sense, particularly when we move beyond the somewhat positivist definition of jurisprudence or law in general? So when we move beyond the traditional the Roman legal tradition, or even beyond the Roman legal tradition. So how do we define those that Glenn calls the chthonic legal systems? And to me, that particular example is an example of law in a comparative sense. It's not necessarily an example of norm, but Sally Engelmary said, well, when do we stop talking of law and start talking about social norms? Is it possible to create that artificial boundary at any point? I think the question is and remains open, and it remains open in a dialogical sense in terms of legal pluralism. So all legal pluralists that I know maintain this question as a live question. It's not something that has been resolved, and probably it's not something that can ever be resolved. Practically speaking, so that's the theoretical answer that I would say. Practically speaking, that particular example to me falls within the indigenous models or indigenous models that we would capture as models that are absolutely to be captured as initiatives. Whether that is always the case, I think that's an open question. I don't know, Craig, Alex, Linda.
It's just, so there's the, I guess, the theoretical, if you will, issue that I think Alessandro has articulated very well. And then there's just the practical issue that, a massive project like this in our first year, we have, with limited resources, we can only track so much to begin with. And of course, and that's why we envision this as, you start with something more tangible or something that's easier to track, just because it's easier to track and you need to start somewhere, with the expectation then it gets built out over time. And so there are a number of, one of the reasons that we are just right now focusing on including initiatives that have some sort of representation, some sort of like formal legal authority structure of some sort, is just simply because we need to have some scope boundaries given our limited resources and time. And it has nothing, it's not at all that we don't recognize other what we might think as more informal, but or just other ones that are that where there isn't a legal document for us to track. And so I think the idea was like, first, let's just try to track what we can track with the legal documents, and then start thinking of ways we can build network relationships to try to identify the others and start to incorporate them in over time. And just as a practical matter, that's the decision we made.
Thank you. And I think actually this brings us to a conclusion for today's webinar. I also wanted to point out that, well, first of all, I want to thank the panelists and colleagues and friends for the presentation. I think that the presentation was incredibly, I found it interesting, even though I was actually there from the beginning. I found it incredibly interesting to see it laid out in this way. I think as a dialogue and as a dialogue, it mirrors the dialogue that we've been having over the past 18 months. I also want to thank all the participants, because most of us are well known to each other. We know each other. We've been working together. We will be working together in the future. For those of us who don't know each other, I think it's fantastic, the opportunity to meet. And I really hope that I look forward to working together in the future. As Oliver, you were saying, so it'll be wonderful to do that in the future. And Lucy, please, if so, you've got my email. You've got if you want to be involved in the Academic Hub. You've got Craig's email if you want to be involved specifically in the Eco Jurisprudence Monitor. You've got Elga's email to ask for a particular question about Elga, and to ask Katie about the event in Siena. One thing actually that I wanted to say about the collaborative work, Matthias, for example, you asked the question about guardianship, and I've been incredibly fortunate to work to see already the work that will come out from one of our participants today, Oluwa Bosayo, who is fantastic on guardianship, and I invite everybody to pay attention to that. She's doing an incredible work on really unpacking the issue of guardianship that I don't think we've unpacked fully yet. So Oluwa Bosayo, I hope you'll be participating in the blog when the blog launches, because it's a fantastic work that you're doing. So this is an example of the fact that our work is interacting continuously, and it will continue to interact in the future. So, pardon me. With that in mind, I would like to thank everybody for today's attendance and participation, and please keep your eyes open and your ears primed for the launch, which will occur fully and officially in October. In between, if you have any ideas, questions, suggestions, anything that you want to contribute, please contact any of us at any point. And so once again, thank you all, and wishing you all the best.
Thank you so much, everyone. Bye. Thank you.